Okay, so again, welcome to Dispute Resolution. Today's topic and our transition is to mediation. So, what is mediation, right? Mediation is sometimes called facilitated negotiation, right? Where the mediator does not impose a decision upon the parties like an arbitrator or judge. So unlike negotiations, right, where you have two parties that are trying to come to a mutual resolution, that are dealing with something that they can be partners, right? And we talked about how if you can partner with somebody that you're negotiating against and change it to negotiating with, then you can come to a range of creative solutions. Mediation, on the other hand, is you have two parties who generally, at least from my experience, like hate each other, legitimately hate each other. And they have some kind of thing, and it can be a wide range of things that they're fighting about, right? And so mediator, there's different types of mediation, right? So your book refers to facilitated negotiation. That I think is a little bit misleading, but it can absolutely happen. So what mediators do is they don't make a ruling, right? So an arbitrator, we'll talk about that, that's a private trial, right? So we're talking evidence and arguments and all that jazz, very formalized structure. And it's not court, right? So nobody's imposing the decision on the parties. The resolution of a mediation should be one that the parties can live with. Now, that being said, mediations, depending on what is at stake, can have one session. Maybe that session runs 30 minutes, or maybe the session runs 4 hours. You might have one that is multiple days of 8 to 5, right? Of arguments back and forth and this mediation. So the mediator plays a really critical role, right? Because you have these two parties that are usually enraged, not always, usually enraged at each other, and you're kind of there in the middle, right? So this is like if you like peace and you're the peacekeeper, right? You're in the middle between these two parties. Now, when you're helping the parties reach a resolution, and that's really your job, is to help the parties reach a resolution. There's different ways that we'll talk about you can do that. You will use a wide range of skills, right? Because mediation is all about facilitating communication between the parties, right? They're there, and you have to think about this, they're in mediation because they couldn't figure it out themselves. But ethically, we say in mediation, the parties figure out it themselves. You're just there to help guide understanding, right? So these parties couldn't work it out outside of having to bring in a third party, and they don't want to judge. They want to still work it out together-ish. It's a really kind of a weird floating thing, mediation is. Because it can have so many different applications. It can be used in so many contexts, right? So when you're facilitating the communication, you're going to use a wide range of skills, as I said. One is a better understanding of each other's positions, right? So if you facilitate communication correctly, each other will understand their positions. You recognize the party's own interest. Right, so remember we talked about positions versus interests and needs. And hopefully we come to a resolution of the conflict, right? And a successful mediation, that's hard to define because you can do everything right as the mediator and the parties say, screw it, we're going to court. Well, that's their decision. That's up to them. That's not up to you. Was your arbitration successful? Depends how you look at it. right? If your goal is to have the parties reach a resolution, then you failed. If, however, you enabled the parties to understand each other better, to communicate better, to recognize their own interests, and they're still going to court over it, but you helped them get that better understanding, then you've been successful. So in mediation, what you're going to want to do is your goal should be, I'm here to help the parties communicate. Nothing more and nothing less. So if they reach a resolution, okay. If they don't reach a resolution, okay. My goal is let them talk to each other. Facilitate a communication that's constructive, one that we'll talk about special tricks you can use to help these parties communicate. Right. So again, the resolution will be something that the parties can live with. Usually resolutions don't, and we'll talk about custody resolutions. Those things are a pain in the butt. But yeah, that's, if you get a resolution, it'll be kind of just a, neither party will be like too excited about it, but they'll live with it, right? And so you can't judge your success based upon the party's attitudes, the party's decisions, anything along those lines. You're there to help communication. So we're talking about preparation for a mediation, all right? We have a couple of schools of thought. One school says we should be a blank slate. Another school says we should know everything about the dispute before we walk into the mediation room. I've found, at least the way I've practiced in the volunteer role here in Elmira, is I walk in basically a blank slate. I know generally what's happening, but nothing like very specific. That being said, even if I have no facts or no knowledge, I can still be very effective if I have proper preparation. So what you will do, and we'll talk about the steps of a mediation, is you need to prepare and practice an introduction and opening statement. All right, so we'll talk about when you give it and all that jazz, but you begin the arbitration. You are the one who starts talking. And we'll talk about what you have to lay out and things like that. So you have to prepare this opening statement, all right? And it'll be generic. If you learn any facts, you can include them, but generally speaking, it'll be a generic opening statement. Your job is to also provide a comfortable and non-threatening environment, right? Because we're trying to reduce conflict. So sometimes working at, like, if you're in a boardroom, that's kind of threatening, right? Especially if you're going to mediation against a company. That's pretty threatening. If you're in, a room, but there's a round table and there's art in the walls and stuff like that, okay, that's more comfortable, less threatening. All right, so we want to de-escalate as much as we can before the parties even get there. Right, and then we have an obligation, and this is where the debate comes in, to read all materials submitted by the parties to the mediation, right? So your job is to know, it is not to judge what they submit. So for mediation, the parties can submit whatever they want, whether it's relevant or not. And you have to put it as a part of the case file. Or maybe it's a custody dispute, and mom wants to show the picture she has of her kid on her refrigerator. Guess what? You have to look at that and you have to put it in case file. So you have to read everything given by the parties without judgment, right? And that's kind of a difficult thing to do because we naturally just kind of tend to judge right off the bat. So if I'm reading materials and one is typed up and has all these exhibits, and then the other one is kind of handwritten and it's only a page on notebook paper, naturally, instinctually, we'd be like, okay, it's clear who's going to win this. But that's where you have to kind of keep in mind that mediation is not about winning at all. It's about communication. So you read the materials, and the parties, the parties to the mediation, the ones having the dispute, they should prepare just as they would for a typical negotiation, right? They will probably choose a win-lose negotiation because they usually don't like each other. So they have to prepare for it like it's a negotiation. Mediator, again, you read everything, but you reserve judgment, right? And we'll talk about this later, but sometimes when you get materials from parties, you have to abide by the American Arbitration Association. It's a association that you can join if you want to. You're not required, but they might come up with rules. So just know there might be some rules that you have to abide by, but you'll know well in advance if there's rules. Generally speaking, there's no rules. Generally speaking, we reserve the American Arbitration Association, oddly enough, for arbitration. But there are sometimes that the parties want rules. And again, it's not my judgment, it's not my place to say what the parties can and can't have, right? So if they want to abide by these set rules, then we'll abide by these set rules. And again, the rules come from the parties, usually not from the negotiator or the mediator. The mediator will lay down some basic guidelines and rules, but nothing specific in terms of looking at evidence and evidentiary hearings and things like that. That doesn't happen. Now, again, as I said before, there's debate over whether a mediator should conduct a factual investigation or go to the mediation as a clean slate. But we all agree that the mediator has to be impartial, that's why before you begin, you have to understand where your head is at, right? Where are you at physically, where are you at mentally, where are you at emotionally, what baggage are you bringing into the room, right? So just like we talked about negotiations, in negotiation, you're bringing your baggage into the room. Right? We all have baggage. You're bringing it with you. And if you're a mediator, you better know what that baggage is. Because if it's something that you cannot take on or that you cannot reserve judgment or be impartial, you have to recuse yourself, right? And the parties will get another mediator. So you have to be impartial, no matter what happens, right? Your job is not there to advocate for one side or the other. You're there to facilitate communication. So if we look at the role of mediator on a continuum, from weak to strong is often situational, right? So when I say weak, don't get the impression that it's shouldn't be used or that it's ineffective or anything like that. We're talking about generally the perception in terms of how severe and what methodology that the mediator imposes, right? So the first method is the one that has become the most common, right? Even though it's like the weakest, it is the most common. It's the facilitative model. Often it's referred to as transformative mediation. Here, the mediator just manages the communication, does very little to suggest resolution to the parties. Instead, encourages brainstorming and helping the parties reach their own conclusion. Right, so transformative mediation, facilitative mediation, we have this notion that the parties themselves are the ones that are going to resolve it, right? I'm here so that, one, they don't kill each other, and two, I can help them communicate better, right? I'm a blank slate. I'm sitting out here and I'm saying, okay, you just said this, right? And we'll talk about active listening and things like that in a minute. Then we have the evaluative model. So this is going to be used in business. Facilitative is generally person to person. Evaluative is business settings, right? And in the business setting, the mediator more actively participates in evaluating the conflict. In the evaluative model, the mediator suggests resolutions and urges acceptance of resolutions, right? So during mediation, the parties can call for a caucus, right? Where one group goes into one room and another group goes into another room, just like in negotiation. The mediator will go into one room and help them try to resolve a conflict and maybe make an offer. And then he'll go into the other room, help them resolve a conflict and make them see the offer and counter offer or something along those lines, and go back and forth, right? And they're actively engaging. They're like, I'm a third party, and look, here's how I see it, right? So that's generally the most common in the business world. When we're talking about a style of mediation that's not really used that often, it can occur if the parties want it to occur. Usually it's going to be in a business setting. What happens is the parties have a single text, right? So that's something that you will have as a mediator. You will write up the agreement that the parties agree to, and it becomes a legal document. In this case, you have the piece of paper, right? And you go line by line, or resolution by resolution, or what their agreements are, and you keep going and you keep changing and you keep editing until all the parties are satisfied with the text of the document, right? And then you sign it, and then have them sign it. So it's kind of like this, you kind of have a contract that you're negotiating line by line, basically. And in this case, the mediator is more of a secretarial role than anything else. So that being said, the one thing that I really encourage you to do, because it's really on the forefront now, is facilitative or transformative mediation. In New York State, we are moving to, in small claims issues, moving to what's called presumptive mediation, as well as custody, presumptive mediation. So basically, the parties have to go to mediation before they can go to court, all right? And the idea is unclog the courts. A lot of the stuff that people argue about is ridiculous. You'll see this like the most ridiculous stuff. And you can't judge it in the moment. Like afterwards you can judge it, but in the moment you can't judge it. But they'll be fighting over really weird, dumb stuff. And the courts are like, yeah, we don't want to deal with it. So we're gonna let community centers or organizations or businesses resolve the issue via mediation, right? Again, custody is a big one, and small claims is the other big one. And we'll get into what transformative mediation feels like in a moment. So here are the essential steps in the process of mediation, right? And again, this is going to be more focused on the transformative mediation as opposed to like a single text mediation, right? And so he said, if you come as a blank slate, right, you sit down. Well, actually what you'll do is you open the door to the room that you're going to have the mediation. You let the parties go in, like you meet before the door, and then you let the parties go in and they can sit wherever they want. You don't sit down until they sit down, right? And then your job is to kind of try to get as close to the middle of them as possible, not being necessarily on the same side of the table, or if it's a round table, that's a little bit more difficult. But that way it doesn't look like you're favoring one side or the other, right? So they choose where they sit, then you choose where you sit. And I talked about not having enough information or being a blank slate. You have an opening statement prepared in advance, even if you don't know what the hell's going on, in which you describe the process of mediation, right? So you would say something like, so this is not a court. No one here is under oath. Mediation basically allows us to talk freely and let you, if you decide to come to a resolution or not, right? The process is I'll ask one party to start by telling me what's going on. That doesn't mean I'm favoring them or on their side. It just means that we're starting with them, right? And usually it's going to be the complainant. Now, throughout this process, if you want to meet with me one-on-one, or if it's a business setting, if you want to meet as a group, you can call for a caucus at any time. What caucus will be is I'll have you in breakout rooms, and you will be able to talk freely without the other party hearing. And I will be in the room, but I will also be in the other room. I will go to both and spend equal time in both, right? And if you need to talk, I'll let you talk before we go back to the mediation room. Now, that being said, there are rules of mediation, right? And you agree to these by coming to a mediation. The rules of the mediation are fairly simple. First is do not talk over another person, right? We want one person talking at a time. The second is be honest. This is a safe space. You can tell us whatever you want. As I'll talk about in a little bit, everything you tell us is confidential. Obviously, there will be no hands or physical fighting or anything along those lines. If someone gets to a place where they are dangerous to themselves, the other party, to me or others, I am required to call 911. I don't think it'll get to that, but I just want you to know that that's kind of how things would play out if there was some kind of an emergency. Now, mediation, you can walk away from the mediation at any time. So even during my speech right now, you can walk away from the mediation at any time. You're here voluntarily, right? So do not feel trapped, and you won't lose, if you want to put it that way, by walking away. All it means is that this dispute will go to court, right? That you'll go back to the small claims court and the judge will make the final decision, right? Now, my role as a mediator is here just to facilitate communication, right? That's one of the biggest problems that we have as human beings is communication. Like we lack those skills. I know I've certainly been in situations where communication would have been a lot more effective, right? So I'm here just to help you all communicate, right? I'm not here to render judgment. I'm not here to solve your problems, and I'm not here to give advice. While yes, I am a lawyer, I am not your lawyer or the other party's lawyer. Again, my job is just to help you talk this out. And again, and it's not a win-lose. If you decide to walk away, that's fine. If you decide to reach a settlement, that's fine. Now, when it comes to that point, as a mediator, my job would be to write down the agreement. Right? And what happens is I'll write it down, I'll take it to the secretary, she will type it up very quickly. You both will sign, and I will sign. It'll be notarized. You will each be given copies of the agreement, and the original agreement will be sent to the court, and your case will be dismissed. If you don't reach an agreement, or decide to walk away, we just notify the court that the mediation did not work. We don't say how long it lasted. We don't say who walked away. We don't say anything along those lines. All we say is the mediation process wasn't for them. That's all we can say to the court. So that's all the court knows. It's just the mediation process wasn't for you. So don't feel like you would be biased or prejudiced in any way. Now, the last thing I would like to mention is confidentiality of the mediation. So anything that is said in this room stays in this room. I am not allowed to repeat anything I hear in this room or what happens in this room to anyone, with a few exceptions. First, I can talk to anybody in the agency or the business, the company, whatever, about the mediation, and it stays in the agency, right? I am required to report child abuse and child neglect, and beyond that, I cannot say anything. In fact, the Attorney General of New York State has said judges cannot subpoena mediators. If they do subpoena mediators, all I can say as a mediator is the parties did not reach an agreement. I cannot say anything else. I can't say what you all said, what I felt. That's the only thing I can say. And again, the Attorney General of the state of New York has made this very clear, right? That anything you say is confidential, it stays in here. And I encourage you on your own to let what happens here stay here. I mean, you're free to talk to whomever you want, obviously, but it would probably be for the best if we kept everything in the agency, right? All right, so that was just like a off-the-cuff opening statement, right? Usually it's gonna be a little bit shorter. You should have it written out. It's not usually great to read from it, but write out your opening statement and memorize it, right? Because if you saw my opening statement, I didn't say anything about what the parties are arguing about. I have no clue what the parties are arguing about. But I can tell them about the process of mediation, the possibilities of caucus. I tell them the rules of mediation. I tell them the role of the mediator. And then I explain to them very clearly the laws regarding confidentiality. So now you, as the mediator, fall back into the shadows. Is what happens is we begin with the party statements, and we begin what's called fact finding. Right, so what we do is generally we gather the facts, right? Basically what I do and what mediators do is they turn to the complaining party and say, Mr. or Miss so-and-so, and they say, oh, call me Karen. And you're like, okay, well, Karen, just whatever they're comfortable with. Remember that some people are non-binary and things like that. So Mr. or Miss could be offensive. You can always try their names, first names. It relaxes things a little bit more, I think. But I always use Mr. or Miss. It's just how I do it. I mean, if somebody is non-binary, then obviously I don't address them as Mr. or Miss. But you know, you're free to do it however you want. And again, how you structure this is going to affect how the parties come out of this mediation, right? So if I structure it in such a way where I'm like, hi, Karen, right? And you're Dave. Wow, that weather out there. Wow, it's looking nasty. We have a short conversation, right? And then okay, well, let's go into the mediation room. Please go ahead and have a seat wherever you want, right? Then I obviously sit down. That being said, usually after I'm done with my rules, I turn to the complaining party, the complainant, and ask, okay, so can you describe for me what's going on, what you're here for today, right? I don't try to use the word complain, like I could, or complaint, because that has a very negative connotation, right? Well, you're complaining again. No, this person has a legitimate grievance. But you also have to keep in mind that maybe the parties you're dealing with don't have even high school degrees. So they may not understand what grievance means. And most people are too shy or too scared or would be too embarrassed to ask, what does that mean? Right? So you want to keep things as simple as possible without treating them like a child, right? Again, how you phrase things, it is very, very important. Now, we start with the side, right, the complainant, and let them tell their side of the story. We don't talk at all. We just let them go. If they want to talk for an hour, they can talk for an hour. They want to say 5 seconds worth of something, they can say 5 seconds worth of something. It's up to them. We do not do a damn thing. When they're finished, and only when they're finished, do we turn to the other party and say, okay, can you tell me your side? Right? So you have this neutral role that you're telling both parties to just tell me what's going on, right? Like, give me your sides. Now, the one thing that you might have to jump in on is parties who interrupt each other. Right? So just like we see in presidential and vice presidential debates, that's a lot. If the parties are, especially in custody issues, if the parties are like that, they're going to start like trying to interrupt and be like, no, that didn't happen, or no, that's not true. And you have to say, Karen, I'm sorry. I asked that you let Jim finish. We agreed to the rules in advance that we wouldn't interrupt. I promise you, I'll give you your time and your side to tell your side of the issue. Is it okay if I let Jim continue? Right? And so what I just did was I basically empowered the party. And we're going to talk about empowerment in a little bit. By asking, is it okay if I continue? But I've already told them, like, you, without a harsh tone, you agreed to these rules, you'll get your damn time, shut up. Is that okay? But I say it in a different way. And it's a way that is friendly, kind, and essentially tricks the party into saying, oh yeah, they might even apologize. And then I tell the other party to continue, right? So I do that as much of that as I need to. If this party keeps interrupting, at some point, I'm going to escalate it a little bit in terms of my tone of voice, right? Reminding them once again of what they agreed to, right? Saying that you're not following the rules. I can't punish them. I can't do anything like that. Like, I have literally no power. My power is my voice and the words that I choose, right? If we have a multi-party mediation, So let's say we have 3 parties. Each obviously gets an opportunity to present their issues and their side of the story. If you have multiple issues that are being disputed, you may, at this point, once the parties finish and make sure that they are done, that they're not just like taking a break for a couple seconds before they go on again. If the parties interrupt you and at any point you stop talking, immediately stop talking if the parties interrupt you. Because it means either they're telling their story or they're trying to talk to you, they're trying to talk to the other party, whatever. We want communication. So let them. If we have multiple issues, we may try to work out an agenda, right, prioritizing the issues. So I would say, so what I'm hearing from Karen, from you, Karen, and from you, Jim, is you're having a dispute over issue A, B, and C. Let me ask you, would you like to address these one at a time or all together? They'll probably just be like, yeah, we'll do it one at a time. Okay, so is it okay if we follow A, B, and C, or would you like a different ordering of the issues? All right, so again, we're kind of incorporating them into the decision, but they don't really have much of a say. This is like the only point where you have any power. Now, if we take this off the table, we just assume it's a simple mediation, right? One I just did was a dog bite case. A dog bit another dog. Right? They were both fine. But the owner of the dog that bit the other dog got some payment from the offending dog owner, but the payment stopped, right? And the vet bill was like $700 some odd. And so they filed for small claims court and they got referred to mediation. That's some of the stuff that you'll be dealing with. Everybody has their own priorities, their own side, and we're not here to judge. Now, if the parties are able to communicate in each other's presence, then we begin an open discussion, right, regarding the issues. So if we have a list of issues, we'll say A. If we just have a simple mediation, we're just going to say, okay, so this is my understanding of what the issues are. Now, if they can talk to each other, that's what we want them to do. We encourage it. So would one of you like to talk a little bit more about this? Right, and we don't lean one way or another. We just say, somebody like to talk about this. If they can't talk to each other, like if they like legitimately like want to stab each other, then we break out into caucuses, right? And I go from room to room, back to room, back to room, back to room, letting the parties talk until I think it's safe for them to come back together, or maybe it's not safe for them to come back together, right? And parties need to leave. That's happened before. We've had to ask a party to leave, and the police officer we called met him at the door with handcuffs because he was threatening, violent, etc. Right, so we don't take abuse, right? We're not the party, we're not the problem. The parties aren't angry at us, but sometimes they kind of put it on us. Our job is to make sure that we're monitoring how we feel about the situation, and if something's going on, maybe there's physical abuse happening, it's a man and a woman or something like that, there's physical abuse happening, you're kind of picking up on that. Again, it's confidential. You can't tell because it's not child abuse. You can't call the police, anything along those lines. What you can do is you can make the parties leave separately, right? So if I had an abuser, I would make him, once they finish their mediation, I would make him leave. I'd watch him turn on the parking lot and make sure he got well down the street. I would then escort the person who I think is getting abused down to their vehicle. right? Not saying anything, maybe just talking about the weather, not talking about the dispute, and making sure that they're safe in their vehicle. So again, that's kind of that self-monitoring that you have to keep doing. Now, usually we're going to ask the parties just to talk, right? You're rarely going to have ones where we bounce back and forth. So we're going to tell the parties, all right, start talking. Tell me what would you like to see happen, right? We just give little prompts if we need to, right? And then fall back in the shadows. Let them talk. We're here just to be here, right? So we fall back in the shadows. So part of what we do while we're in the shadows is we try to get issue clarification and option generation, right? This happens when the mediator kind of proceeds to guide the parties to beyond what happened in the past and focus on their vision of the future. So this isn't necessarily transformative, because transformative, your job is to clarify statements and to empower parties, not necessarily to guide them, right? So in transformative mediation, if the parties want to talk about something that happened 6 years ago, let them. I mean, if it has nothing to do with the dispute, let them talk, right? They need to get it out. They have their baggage. They're opening their baggage. They can't deal with the issue that they came here to deal with until they've dealt with this baggage that they've brought along. So let the parties talk. Now, we'll talk about what you do in the transformative sense in terms of letting them talk. It's basically based on empowerment. If an impasse is reached, right? Impasse is both sides have dug in, they will not agree, there's no happy medium, my way or the highway, both sides. Then you come back in from the shadows and you say, well, it seems like we have an impasse here. I'm going to call for a caucus. What a caucus is a one-on-one meeting with me where you can tell me anything that you want, anything that maybe you don't feel comfortable sharing with the other party, and I can't repeat it. And just explain to them again what the caucus is. You can also call for a break. Say, oh my goodness, we've been sitting here for a little while. Does anybody else want coffee or something? And what you do is you let the parties get up on the break and leave the room, and you ask them to leave the room if they don't, and then you leave the room after them. You do not leave the room with a party, walking next to a party, near a party at all, right? We don't want to see anything that looks like you're favoring one side or the other. You can also facilitate creative problem solving. So this is not necessarily transformative, but this is the idea of the parties working together to come to some agreement. So this really reflects back to negotiation, right? When we're talking about creative problem-solving negotiation, that's something that you could facilitate, right? And how you do it is how you do it. In terms of your style. I have a style, but I'm also limited in my style by the agency that I work with. In the firm that we're starting, I'm not limited, right? So my style might change. You can mix things in together, right? Keeping in mind, your job is just to get them to talk. So you can facilitate creative problem solving, but you better not come up with an option and give it to them, because then you're not a mediator, right? Because they're going to be like, oh, that's a really good idea. Or they say it's a really bad idea. Or they're going to do what probably happened is call you out for favoring one side over the other, and they storm out, we're going to court. You don't want that one to happen. Like, that's a bad one. So again, impasses, there's ways around it. But we're issue clarification, option generation, we're wanting them to talk. Now, if we continue with this idea of listening, right, we help the parties express themselves. And if necessary, we verbalize the parties' respective interests beyond past transgressions. Right? So what we mean by this is if the parties are having a dialogue, right, and they're talking, and you kind of see what one party's trying to get at, but they're not getting there, you can jump in and say, oh, Karen, that last point, could you help me understand that better? And she'll talk about it, and then maybe they'll generate something like that, right? So you can play a little interference. What your main job and what your main looking out for is parties that are being loud or difficult. So if you're a mediator and you're in a mediation and the parties are, like one party is screaming, slamming stuff, whatever, your attention should be on that party. But you're not there to judge that party. You're not there to tell, you do not tell the party to calm down. You do not do that. Again, if it's emergency, then that's a whole other situation. But you don't. Because what science suggests is the person who is being the loudest and slamming things and acting the angriest and kind of seems out of control, they're doing it subconsciously to feed their reptile brain because they feel weak and they need to be heard. So it's crucial that you engage in reflective listening, right? It's crucial to the dynamic. It shifts basically and empowers that weak person and recognizes their needs, right? So you have one slamming stuff down and you know, this whole process is bullshit. You use their own words. You say, so Jeff, you think this process is bullshit? And it's amazing. The person will stop in their tracks and realize, I just said, I didn't mean to say that. You have one that, I had one that was, I'm trying to think of what they said. You're just too difficult. I can't stand you. And I'd say, you know, so Jeff, what I'm hearing is you feel like Karen is too difficult and that you can't stand or work with them. Is that right? And what the idea is twofold. One, the party who is weak just got empowered because I put attention on them. And second, and more importantly, they got recognition, right? They were heard. That's what weak people, that's what people in arguments want, is they want to be heard, right? And so if you repeat back to them exactly what they say, then you know that, or they know that they are being heard. And usually they'll calm down. This is something that I recommend you do on a daily basis, not even in mediations, but you get in a fight with a significant other, you get in a fight with a parent, or you see the parents fighting or something like that, but even if it's a one-on-one, you the other party's really, really ticked off, yelling, you can calmly say, so Karen, what I'm hearing you say is X, Y, and Z. Is that right? It's amazing what will happen. I wish we could do this live because you would see, and we're going to do role plays, but you'll see the person like literally stops in their tracks and calms down immediately. It's a really it's a cool tool to use in your daily life, but it's an absolutely necessary tool to use in mediations. Now, some phrases should trigger you to kind of step in, right? You're in the shadows for most of the talk. But if you hear some certain phrases, and these are just examples that I have, these aren't like the only ones that you do. you jump in, right? And you jump in with, so what you're saying is this, and Bill, what you're saying is this, right? So this is where you jump in. Phrases such as, this is the first time I heard that. He never said that before. So Karen, what you're saying is, you haven't heard this before. This is the first time that he's mentioned this. Is that right? And then they will explain, they'll calm down, they'll explain more, and you keep empowering them until the parties are equal. They're on a level playing field, right? You do not understand. So Bill, what I'm hearing you say is Karen just isn't understanding what you're trying to say, right? So you can use their words, and if they curse, use their curse words, like even if you don't curse. You need to know where I'm coming from. Now this one's a really key one, right? Because that's the whole point of mediation, is for the parties to see where they're coming from. So this is, Karen, it sounds like that it's really important to you that Bill understands where you're coming from, what your position is. Could you elaborate? Right, so I've just gone past a position, now I'm getting to their needs, right? And then as soon as I'm in, I'm out. Like, I mean, in and out, just snap in, snap out, and let them talk. So you give them a low prompt and you just step right the fuck back. Other keywords, opportunities to jump in. This is exactly what I would expect you to say. Okay, you jump in and write and repeat the words back to them and ask them to clarify or to go on or something like that, so they feel empowered and they're heard. Problem is when the party will, and this will inevitably happen, the party looks at you as the mediator and says, what should I do? Remember, that is not your job, right? You are not there to resolve the parties' disputes for them, because we believe ethically the parties have the tools themselves to resolve the conflict. So if somebody asks you, let's say Bill, Bill says, I'm frustrated. Well, you're a professional. What should I do? You turn to Bill and you say, you don't say, that's not my job. You don't say anything along those lines. You turn to Bill and you say, so Bill, it seems like you're wanting to get an outside opinion on the disagreement that you have with Karen. Am I understanding that correctly? All right, see, what I just did is I deflected, right? I used active listening, I repeated, I empowered, and now he's gonna say, well, I want somebody to jump in and somebody to be a judge here. Well, then the other party's gonna jump in and be like, a judge? When you wanna go to court, I'll go to court. And then you empower that other party, right? So the idea is you're kind of playing back and forth, keeping them level and never resolving their dispute for them, or even like helping come up with solutions. You do not do that. A lot of times you'll hear, this is no use, or there's no use to this mediation. It shouldn't even be here. Reflect back. So Karen, you feel like that mediation isn't appropriate for this dispute. Could you elaborate a little bit more? Right, you're using it against them. If they come up with an idea, that will never work. You jump in, say why. This is ridiculous. You jump in, get a why. You'll get this one a lot too. It's kind of the same thing as what should I do? You've worked with a lot of people. What's the answer? And you don't say, well, I don't have the answer for you. And you certainly don't say, you're stupid, do this. It's really hard not to. And I'm being completely honest. It is extremely hard not to say, you're an idiot, just do this, right? Because you're an outside observer. That's not your job. And you have to bite your tongue, right? And then you repeat back to them. So it sounds like you're saying that you want an outside opinion, somebody who's dealt with things like this before. Is that right? And let them go off. All right, so you deflect. The one that you will almost always get, if it's a small claims case, is the party will stand up, gather their belongings, and say, we're taking this to court, or I'm going to court. And remember, your job is to let them if they want to. It's their mediation, not yours. It's their decision. But what's going to happen is you want to empower that person. Even though they're standing there ready to go. You say, so Karen, it sounds like you feel like the mediation isn't working and you want to go to court. Yeah, because he did da-da-da-da-da, right? And then she goes off about what Bill did. In that case, what's going to happen is she's going to stand there. They're going to argue for a couple minutes. She's going to put her stuff down, take her seat, and then they're going to keep arguing. Like it's seriously, they can have their hand on the doorknob, and you say, so it sounds like this. That's empowering them, right? If somebody's like wanting to leave, remember fight or flight, right? That's a basic human instinct. If they're saying, let's go to court, what their brain is screaming is run away, run away, run away, right? So your job is to make that little voice in their head shut up, right? Your job is to say, oh, so you feel like this process isn't necessarily working, that you'd like to go to court. Well, I don't want to go to court, but, and then they'll go off, right? And then they'll inevitably sit down where they were. It'll be a slow process. They'll sit down where they were, and then they'll just keep arguing. It's really, really empowering. It's really interesting. That being said, there are some such situations where maybe in your best judgment, you let that person walk out. There could be a safety reason. It could be the fact that this person or this dispute is not appropriate for mediation, that a judge should handle this, or that a judge should be aware of this, right? So this is especially true if we're talking mediation that involves domestic violence, right? If I have an abuser who has his hand on the door and says, we're going to court, I am not saying a damn thing. Let him. Because then you get to explain, Mr. Man, to a judge that you've been abusing your wife, right? It's kind of like a fuck you in your head. But that's where you use your best judgment. Most of the time, you're going to want them to sit down and talk. So you just say, oh, so it sounds like it's not working. If it's an abuse situation, again, child abuse, you have to report. But if it's an abusive situation, or if it's a situation where you're like, wow, this shouldn't be here. I should not be doing this. Let them walk out, let them go to court. The courts are equipped to deal with it. If you're not equipped to deal with it, they are. If we continue along, we can select alternatives in decision making. So basically, the step it's basically a negotiation. The mediator does reality testing. Now, this is not transformative. This is kind of more the traditional model. With all the parties, in which each party is directed to look critically at their own position and decide whether they're being practical in their demands. Right? So let's say Bill's like, well, I want $5,000 a month. Karen says, I can only afford $20 a month. So we say, okay. They talk back and forth, and I said, well, okay, fine. I'll pay you $100 a month. And then you say, okay, it sounds like you have reached an agreement on this issue. That'll be multiple, but like this issue of $100 a month. Bill, is that your understanding? Karen, is that your understanding? Okay, what I'm going to do is I'm going to write it down as something that we've agreed to, and you are free to change it at any time before we sign it. If it's one issue we're dealing with, we're just going to be like, I'll have them type it up and you'll sign it and you'll be on your way. If it's multiple issues, then you move on to the next issue. Parties can explore, the mediator theoretically can explore non-agreement options, right, and the party's best alternative to a negotiated agreement as a part of the process. So if you're doing transformative, you don't want to say like, hey, there's a non-agreement here. But if it's going on and on and on and on, and you're not getting anywhere, you can kind of interject, right? And again, you're empowering, but you can kind of interject and say, so Bill, what I just heard you say was you would accept $100 a month. Karen, are you able to afford that? Right, so if we're getting nowhere, I can jump in and do a little bit of, again, reflective listening. I just told Bill what he said, and then I asked Karen in a very nice tone whether or not that was agreeable to her, right? And that kind of gets you over that hurdle of they're just arguing back and forth and this is pointless. A lot of mediations go to court because the mediator just says, meh, they're not agreeing. It's been an hour and a half. I'm done. But no, that's not your decision. How long this thing lasts is up to them. And if they want to argue back and forth for 4 hours, let them. Because if you're doing it for a private agency, you're getting paid by the state. If you're doing it for a private company, you're getting paid by the company per hour. Really well. And the parties are the ones who are paying your way, right? They're paying you per hour. So if they want to bicker back and forth for 4 hours and I'm billing at $120 an hour, let them. Right? That shouldn't, and I should say you have to be ethical. You can't like just try to steer them in a direction where they're going to talk more for no reason aside from money, right? But that's something that you can do. Mediator may make suggestions and encourage the parties to explore alternative settlements. I say, and especially in transformative mediation, like, do not make a suggestion. Because then the parties are going to start attacking you, right? You are now inserting yourself into their lives. That is not your job, right? Your job is to pick up and listen and say, oh, that sounded like an offer. Let me jump in and explore this. That's your job. Your job is not to say, well, what if we did this? Because then guess what? Those parties are going to turn on you. You are now the enemy, right? And they're going to accuse you of favoritism or stupidity or whatever it is. And you can't come back from that, right? I mean, once the party is done with you, the party is done with you. Instead, what we do in transformative mediations is we use what's called check-ins, right? So the party's been arguing for a while, and maybe, and this is especially true if a party is silent. Like one party is just going off, blah, 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 right? And the other party is sitting there silent, or their body language indicates that they're not comfortable, right? So like they have their arms crossed or their hands clenched together or their head down. That should be a red flag for you. This person is literally at the bottom, right? And so you'll say, okay, you repeat Bill, so I heard you say this, and this. Karen, I haven't heard a lot from you today. What do you think? Right? And the idea here is you're telling Karen and you're validating Karen by asking for her thoughts, and you're giving her an opportunity to give those thoughts. Now, if both parties are arguing back and forth and they're both talking, you can say, hey, sorry to interrupt, guys. You know, what I heard was this, and I heard this. I just wanted to check in and see if we wanted to explore another avenue, or if you want to stay in on this topic. You can do that, right? It's really one of these things that you learn by doing, but you'll get instinctually, you'll know what to do, right? So don't fear the fact like, oh, I haven't done this before. Instinctually, you'll know what to do. Then, assuming the parties agree, we get clarification, all right? So the parties come to an agreement. I, as the mediator, pause, and I say, okay, as opposed as it goes for the issue of the dog bite. Karen, you've agreed to pay $1,000 a month to Bill. Is that right? And Bill, is that right? Okay. Now, how would you like me to word this? Right? And you write down their exact wording. Even if it's improper grammar, even if it includes cuss words, you write down their exact wording, because that is what they've agreed to. You don't get to edit what they agreed to. They've agreed to it, right? So then once they've agreed to the part or the positions, you get the agreement typed up, usually by secretary. It's committed to writing. The parties sign it, right? It's notarized. They have to show their IDs, etc. Most of what you will deal with should, when in doubt, get it written down. There are some cases where it's so like minor and trivial, like there's no point writing it down, or if the people are like really close friends, and they just can't get over this one hurdle, and they just need some help. I'm like, okay, like you guys trust each other, and whatever. But in general, write it down. Divorce mediations provide a very unique challenge, because these two parties hate each other. And they're talking about a lot of things, right? This is usually a distribution of property. Included with this is custody. Custody disputes are somewhat terrifying, because people are so passionate about it. That being said, I say custody that relates to a dog or a cat, or excuse me, a kid. If we're dealing with property, and it's considered under the law as property, a dog, a cat, a hamster, whatever, I'm even more cautious, because the most fought over thing in a divorce in court is the animals, excuse me. Kids are second, animals come first. And what's interesting is if this party, they go through court, right? The judge is not going to give a shit, one, and two, is going to award the dog to one of the people. There's no such thing as visitation rights or anything like that when it comes to animals. It's yours, right? And the judge says it's yours. And so you can say, no, the other person can't come see it, can't do anything like that. In negotiation and mediation, right? Mediation, you can provide that avenue for them to have visitation with an animal, right? It's their agreement. It's what they want to do. It's not me imposing my judgment like a judge would. It's what's going to work for you all. Custody, that one gets tricky in the sense that sometimes the parties don't think things through. So one thing that you should always have handy is a paper calendar. Usually if you have like a desk calendar, that's awesome. Because parties forget about holidays, parties forget about leap years, parties forget about all kinds of stuff, right? So there was one custody dispute where the wife wanted custody of the children over the summer. The man wanted custody the rest of the year and on any major holiday. And that's what they initially agreed to. The problem is what holiday occurs in the middle of summer? 4th of July. That's a major holiday, right? Mom is supposed to have them all summer. Dad wants them on major holidays and the rest of the year. Guess what? When we go through the calendar and we get to July 4th, guess what's going to happen? They're both going to go at each other again, right? And we might backtrack. We might have to erase everything we wrote on the calendar because they've decided they're changing the agreement. Well, that's their job. I mean, that's up to them. That's their agreement. It's not yours. It's theirs, right? So, yeah, like I said, it's a very interesting situation when it comes to custody. And you also have to take into account there are certain laws that you have to abide by, things like that. Also, you have to understand and help them understand that they also have to, if they're going to be a legal guardian or if they're going to retain sole custody, they may be entitled to child support, right? In a court, they may be entitled to child support. Here, they're not entitled to anything unless they agree to it, right? So you do want to be ethical in the sense of suggesting that, you know, if this went to court, there might be a child support. You could go that way, or you could go with, so you've agreed to take sole custody of the child. Is there anything that you need or want to talk about in regards to that child and that child's welfare? Right, and so you're kind of driving them down the road of, so do you want child support or not? Right? And again, they're going to fight over it, and it's going to be a nightmare. But that's when we talk about complex things. Divorces are complex, especially if it's custody, because there's somebody else that gets involved in custody disputes. The kid. So the kid might literally be sitting in the lobby, and mom and dad are screaming about when they want the child and when they don't want the child. It is not improper to suggest that we bring the child in. So you might say, well, it sounds like you both have really firm positions, right? You want them this many days, you want them this many days. Would you like, or would it be helpful if we brought in little Johnny so he could give his opinion? The parents at first are going to get real skittish. And they may say no. They say no, that's that's up to them, right? They may say no right off the bat because they've just realized they're going to have to tell their kid, I don't want you on certain days. Or I don't want you, right? You're going with mom. They have to tell their kid face to face. Guess what's going to happen? They're going to say, well, let's talk about this a little bit more before we bring them in. If a kid comes in, depending on the age, is how you should treat the child. If the child is little, you don't make them choose between mom and dad, all right? You just have them in the room, because that's going to make mom and dad act like adults and also realize, wow, there's this precious human being that, you know, I'm a part of. I should be an adult and step up, do the right thing. If they are teenagers, You can ask their opinion as to how they would like to spend their time. And it might be really hurtful, right? It might be like, no, I want to spend my time with dad. I don't want to be with mom. And so you turn to little Johnny, you say, little Johnny, it sounds like you're saying you want to just be with your dad. You don't want to be with your mom. Is that right? So again, you're using transformative mediation. You're, more importantly, not only has the kid said it, but now you've said it. So mom and dad have heard it twice. Then they can start arguing. You can let the child leave. You can say, thank you, if you have a seat back out there, and whatever the parties want is what they get, right? And so that's basically, in a nutshell, mediation. Now you'll see if you pull up this on your slides, there is a role play mediation with a neighbor-to-neighbor conflict role play. I encourage you to watch it. I can't play it here because of copyright issues and because of timing issues, but I encourage you to watch it to see what it's like. Now, it's not that entertaining, but it gives you, but watch what the mediators do. Watch their position, watch their hand. And it's not uncommon, like here, to have two mediators, right? And the idea is like, you have people who can catch things, mediator situation. What I will say is it creates an interesting dynamic in the room. I'm gonna stop recording.